To all of you, and I'm very glad to participate in this first event, as Nicolas Charby has reminded us. First time that Concurrence, together with Bremer law firm, have shown an interest in the development of merger law in the Middle East and in the MENA region in general. There's a lot of activity going on in that region on the merger front, which is one of the reasons why we decided to organize the seminar with different countries at different levels, either adopting a merger law, and we will hear from the UAE Ministry of Economy about the recent development in UAE, or upgrading the merger law. We will hear from Egypt and the Egyptian Competition Authority about the developments and massive developments in Egypt. But we will also hear how Egypt was able to control merger without even a merger law originally. And then we have countries which are stepping up their activity in the area of competition law, and we will hear in particular from the Moroccan Competition Authority, which has been controlling merger for quite a bit of time and has a vast number of cases that it has dealt with. Now, we're going to talk both about the substance of the merger control law, but also about the procedures, and in particular about fast track, about threshold for notification, about all the apparatus that one needs for merger control, or that one has for merger control. So to organize our discussion, we decided to divide the topics into 4 categories. The first one are the recent developments in each country in the merger control law. The second is to give you a view of the state of enforcement and some of the most interesting cases which have been dealt with in the 3 countries which I've mentioned. The third topic is what is in store, what are the challenges, but also what are the perspectives when it comes to merger control law. And finally, to have a short discussion of cooperation, because, of course, when one controls merger, there are a number of mergers which have implications in other jurisdictions, and then the question arises of to what extent do the competition authorities, which are dealing with the same merger, cooperate with each other, particularly, for example, for the design of remedies, but possibly in other ways as well. So without further ado, and given the fact that we have only 1 hour, I'm going to turn to our speakers. So as I mentioned, Hannah Kouailed will speak. She's the head of the Economic Concentration Department of the Egyptian Competition Authority. Shameh Abu is the Council Vice President of the Moroccan Competition Council. Mohamed Jahani is a director of competition in the department of the competition department in the UAE Ministry of Economy. And we also have with us Nicolas Bremer, who is the partner in Bremer, a law firm which has been quite active in the Middle East and the MENA region and knows very well and will give us the perspective from a private practitioner after we've heard the perspective from the competition authority, so we can have a balanced presentation of the issues. So without further ado, I would like to turn to our first topic, the recent developments in the 3 countries that are present with respect to merger control law. And I would give the floor first to Shameh Abu from the Moroccan Competition Council to tell us what have been the most important developments recently. So, Ms. Abu, you have the floor.
Good afternoon. Thank you, Professor Frederic and Concurrence for setting this panel together. It's a great pleasure to join you today to discuss merger control and competition enforcement in MENA region, a special region where competition regimes continue to evolve rapidly and where institutional experiences remain highly diverse and various. From a Moroccan perspective, the development of merger control is much more than a legal reform story. It reflects deeper transformation of economic governance driven by constitutional reforms, institutional development, and also Morocco's growing integration into global markets. Morocco's merger control regime is firstly rooted in law 104/12 on freedom of prices and competition, as amended and supplemented by law 4021 in 2021. The 2021 reform wasn't cosmetic; it changed our notification thresholds, sharpened our procedural tools, and embedded modern analytical criteria directly into the statute. And in Morocco, like most countries around the world, merger control thresholds are used to decide when companies must notify transaction to the council. Before that reform, Morocco had a single notification threshold based on worldwide turnover. And the reform quickly made the merger control system more active and we can say effective. Today, Morocco applies a hybrid notification system based on 3 alternative thresholds. The most significant reform is the 2023 decree. The system is based on double turnover test. First, the deal must exceed the global turnover threshold, meaning the companies generate significant worldwide revenue. Second, there must be a local nexus, which is very important. That meaning at least one party has a turnover in Morocco, and both conditions are required for notification in most cases. There is also an additional filter, market share thresholds of around 40% of in a relevant Moroccan market. This allows the authority to review transactions that may raise competition concerns, even if the turnover is not very high, especially in concentrated sectors. And if I can give some statistics about merger control, in 2025, the Competition Council took 180 merger decisions, which is a significant increase compared with the previous years, up 17% from 162 in 2024. And what I can say is that the legal framework has also been updated to include digital markets, innovation, and sustainability in merger assessment. In practice, I want to share with you the idea that the authority in Morocco no longer considers mergers only on traditional economic factors like prices, the market shares, or competition levels. It also considers broader factors and how markets may evolve in the future. I think it's enough for development. If I can share some ideas about procedures.
Maybe we'll come back to this in the second part. So maybe we should stop here for the first round. what you've heard, of course, is one of the issues that all countries face is how to set the threshold for the notification of mergers, which is going to determine the volume of mergers that the competition authority is going to have to deal with. And of course, there are competing considerations. On the one hand, you want to make sure that the threshold is low enough that all the significant mergers, the ones that could impair competition, are notified. And on the other hand, you don't want it to be to have so many notifications that the competition authority is completely overwhelmed by all those notifications. So, and finally, you want to have a local nexus, and which can be in turnover or in market share. So we've seen that there've been development there in the case of Morocco. So let me turn now to a second presentation by Mohammed Sultan Janahi for the UAE. This is a different context. This is the context of a country which is coming to merger control. So we will hear about the developments and the efforts to establish a working system. Mr. Jahani, you have the floor.
Thank you very much, Frederick. And thank you to Concurrences and Bremer for organizing this important event, and as well as the attendees for attending. And I look forward to engaging with you during the question sessions. So we've had quite major developments in the UAE over the past couple of years when it comes to our merger control environment, and also our competition law generally. In 2023, a new law was adopted, replacing the 2012 law, and it had major changes, including a thresholds decision, which was passed by the cabinet a year after the law, which introduced new sales thresholds, which didn't exist in the past. And those are set at 300 million dirhams in the relevant market. And that's around $82 million combined sales from the parties. As a result, we've seen a pickup in terms of the volumes of applications being submitted to the ministry. While they're still humble, we are doing a lot of outreach and awareness to raise the awareness of the new requirements, and also avoid taking enforcement actions just because certain parties who are used to the old conventions have not understood the new ones. And then most recently, we've passed a month or so ago the implementing or the executive regulations for the law, which are very detailed in comparison to the previous executive regulations, and cover a lot of new issues when it comes to mergers or economic concentrations. We're starting to look at issues that we haven't looked at before, in line with international best practice. And those include competitor market shares, the information of customers from the parties. We identify the different affected markets. We require information on any previous economic concentrations, including JVs, and also in some cases, consumer impact assessment, expected impact on prices and availability of products, and also any proposed remedies from the applicant side should they identify any issues. We were also provided an opportunity for market testing, where we would publish that we've received certain applications for stakeholder perspective, as well as objections from any relevant stakeholders. Our investigation powers have been enhanced. We can have dawn raids now, hold various meetings with parties, engage with various authorities across the country, and require documentation from the parties in a manner that wasn't available to us in the past. Also, we've clarified filing responsibilities. So, for example, in an acquisition, the filing responsibility sits with the acquirer. For mergers and joint ventures, it's open to any of the parties to submit. So these are some major changes in our merger regime, and that we are testing, and we will continue improving as it's being used by the market. Thanks. I'll hand over back to you, Frederick.
Thank you very much, Mr. Janai, for that. I think that there are a number of issues which are very interesting that you've mentioned. One of them is the fact that you mentioned the adoption of market share threshold for notification. So that, of course, speaks to the fact that in a country of relatively small size, you may have small markets, so the turnover is very low, but at the same time, you have a high level of concentration. So you might want to make sure that the concentration does not increase. And in those cases, thresholds in absolute value may not be so useful, because for other sectors, they would bring to the competition authorities mergers which really don't create a competition problem, and it would just be a burden on the competition authority. So even in Europe, for example, in Portugal, precisely because Portugal is a small country, they have adopted thresholds which are in market share as well as in absolute value. Okay, so that's one thing. The second thing is, of course, the fact that to do merger control, you need a lot of information, a lot of data, and that you need the competition authorities to be able to gather this data, because very often it's the market participants who have the data. So therefore, the ability of the competition authority to secure information that will allow for the analysis of competition following the merger is quite important. Let's turn now to Egypt and to Rana Kawaled to see what have been the development in Egypt recently. There have been some stunning and important development, but I think that she's also going to tell us that even before there was merger control still existed, at least in some sectors in Egypt, because the competition authority were following those sectors very closely.
Thank you, Professor Jenny. Thank you so much. I'm delighted to be part of this webinar and to share the Egyptian experience with you. So regarding recent developments in Egypt, Egypt's ex-ante merger control regime was introduced by law number 175 of 2022, amending, of course, law number 3 of 2005 on the protection of competition and prohibition of monopolistic practices. The law entered into force on 30 December 2022 and became operational on 1st of June 2024, following Prime Ministerial Decree 1120 of 2024. You will find the relevant articles in the law in Article 2G, H, I, Article 19 bis to 19 bis F, Article 22 bis D, and of course complemented by the articles in the executive regulations from Article 48 to Article 62. The regime captures all transactions that results in a change of control or material influence, and control is defined by the law as the ability to exercise influence over the economic decisions of the target firm, meaning the pricing decisions, for example, while the material influence is defined by the law as the ability to exercise influence over the long-term strategic decisions of the target firm. And I think that it's important to highlight that the inclusion of the material influence is one of the distinctive features of the Egyptian merger regime. And the reason behind such inclusion was that in practice, ECA has witnessed a lot of cases where we could see the impact of cross shareholding structures on coordination and on alignment of competitive behaviors between competitors. So simply non-controlling minority shareholding are falling short of control. However, they may have a significant impact on competition. So it was a deliberate legislative choice to not only address the issue of non-controlling minority shareholdings exposed through antitrust enforcement, but also at the outset through merger control. And then we have the notification thresholds, which are basically based on turnover and value of assets. And we have two thresholds, one domestic and one international. As for the merger review process, we have two phases. Phase one, which is 30 working days, extendable by 15 working days in case of submission of commitment offer by the parties. And then we have phase two of the merger review process, which is 60 working days, likewise extendable by 15 working days in case of submission of commitments offer. And of course, in both phases, silence equals approval. So the lapse of timelines without an ECA not issuing any decision, this means that the parties have taken the approval of ECA. Regarding the substantive test, Article 19 bis B states that any transaction that may have as effect to eliminate the freedom of competition should be prohibited by ECA. And here the standard is broader than consumer welfare. And of course, the executive regulations and specifically Article 54 of the executive regulation complement Article 19 bis B with a list of factors that may be taken into account by ECA when assessing mergers, such as the factors are or include the structure of the relevant market, potential competition, actual competition, barriers to entry, and broader factors also, such as the impact on investment and the impact on innovation, for example. And of course, we have some sanctions. The sanction ranges between 1% and 10% in case of non-compliance with any of the provisions of the merger regime. The 1 to 10% are from the turnover, value of assets, or the value of transaction, whichever is higher. However, as Professor Jenny mentioned, the story of merger control in Egypt did not start in June 2024. Actually, since 2021, the ECA had been exercising effective merger control in the healthcare sector through its advocacy mandate and cooperation with sectoral regulators mandate under Articles 11.5 and 11.10 of the Egyptian competition law. the Ministry of Health and Population and the Egyptian Drug Authority have established a systematic referral mechanism, meaning that all notifications received by the sectoral regulators in the healthcare sector were forwarded to ECA for prior competition assessment. And from the side of ECA built a structured review process with dedicated timelines, notification forms, databases also in order to expedite the procedure, and dedicated decision-making committee. And from 2021 to 2025, we have reviewed around 1,314 files in the healthcare sector, with an average time review of 11 working days for the pharmaceutical files, and 12 working days for the files of the Ministry of Health and Population. So I think that the Egyptian experience may reflect the importance of the adaptation to one's legal system and economic reality, and also the importance of the creative use of existing mandates for young authorities or emerging regimes that may help young authorities to exercise effective merger control even before the adoption of a former regime. Thank you so much.
Well, thank you very much for this. You made a number of important points as well. And your last point, I mean, the point that one can use advocacy when one doesn't have formal powers to look at merger, maybe something that some competition authorities want to consider, because it's quite frequent, in fact, throughout the world, that competition authority or competition law originally do not have merger control, and that comes after some number of years of experience. And the second thing that you mentioned, which I want to point out, is the difference between the phase 1 and the phase 2 investigation, which allows the competition authority to eliminate, so to speak, fairly rapidly the mergers that really don't create a problem. So if you see that there is no prospect for a problem in phase 1, well, usually there is no phase 2, but there is a phase 2 if you think that there might be a competition issue with this. Okay, so now I think it's time to look at the state of enforcement. What are those laws used for? And I would like to turn to Mr. Janahi. We understand that UAE is in the process of adapting a modern merger control law, but I think that you've already had some experience with some cases. So if you could briefly explain to us what kind of enforcement you have been engaged in, that would be very useful.
Sure. Thank you, Frederick. You're absolutely right. It's still very early to start enforcing in a manner that might create disruptions to the way markets operated for a very long time. However, in certain cases, and in one particular case, where that specific relevant market was subject to a separate competition investigation regarding exclusivity. While we shortly after it was completed, one of the key market participants, although not subject to that investigation, conducted a merger at a global level, and did not make the required submissions, and went through with the transaction, which provided us with the ability to investigate our first gun jumping case. Unfortunately for the parties, we haven't yet issued our administrative penalties decision. So our decisions right now, the fines and sanctions in the law are now judicial at this stage. So, which is quite hefty, that can go up to 10% of sales volumes and all sales volumes, not even in the relevant market in the previous year. So this was a very important case for us, and it was an opportunity also to raise awareness in the market of the competition law requirements. But as the UAE has established itself as an environment that, while it welcomes business, it implements regulations across various fields based on international best practice. Having said that, we've opted in this case to go for a private warning. The culture is still perhaps not there to publish and take heavy-handed action, because the fine would have been in the millions, in the tens of millions. And given that it's the first incident, we've decided to take a more reserved approach. But since then, our inquiries have increased. I guess word went out in the market, and our filings have increased. While our numbers remain humble, but comparison to previous years, they're doubling at least this year and last year. So that's a positive indicator for us.
Thank you very much for this. And indeed, gun jumping is something that young competition authorities, when they start implementing merger control, are faced with. And there are many different reasons, but one of them is the fact that sometimes the operators are not so well informed about the existence of merger control law. And sometimes they are testing, to a certain extent, the resolve of the competition authority. So having provisions that allow the competition authority to intervene if a merger that should have been notified and the threshold has not been notified is quite important. And so you took a pedagogical, I would say, approach. But I'm sure that if you come across other gun jumping cases, slowly but surely the competition authority is going to be a bit more severe with respect to those practices. Let me go to Hannah Kowaled and the case of Egypt. You did something which is quite important. I mean, you mentioned something which is quite important in your first intervention, which is the fact that the definition of what is a merger is the acquisition of a significant influence on the target. And I just want to mention the fact that one finds two types of merger control laws in the world. Some of them say is the acquisition of a certain share of the capital of the target. I don't know, more than 50% of the target, that's it. And others are written in a more subtle way, I would say, as the Egyptian law, where it says, well, it's any acquisition of a decisive influence on the target, because that is when there could be a competition problem, because the merging firm is controlling the target in its strategic decision, and they don't become independent on the market anymore. So that could be a good test. So Hannah, can you talk a little bit about the enforcement issues in Egypt?
Yes, of course. Thank you, Professor Jenny. I will present two cases that reflect the particularities of the Egyptian regime, one under the framework of the informal mechanism and one under the new merger control regime. So to start, I will start with a conglomerate merger case. In 2022, we have received a referral request from the Ministry of Health and Population regarding the acquisition by one private multi-speciality hospital, which is active in one governorate of another hospital, which is active in another governorate. So basically, we have at hand geographic extension conglomerate merger, meaning that parties provide the same services, however, in different geographic scopes. So ECA here advanced two theories of harm. The first one was the leveraging effect. And basically, ECA highlighted that after the transaction, the acquiring firm may transfer its market power from one market to the other, from one governorate to the other, especially in front of the health insurers, where that are the common consumer between the two governorates. And then we have the second theory of harm, which is basically a portfolio effect theory. And basically here we advanced that after the transaction, the new entity would have a strong portfolio constituted of must-have brands, which will enable the new entity to increase prices with a cascading effect, of course, on competitors, on patients, and on health insurers. And actually, these theories of harm are not without precedent, because when we see the earlier decisions of the FTC, for example, and the entrenchment theory of harm and the reciprocal buying theory, also some decisions of the European Commission, and here I may recall the decision of Tetra Laval Sidal. I can see the same theories of harm before, of course, the shifting towards a more economic based approach. And then we have another case, which is very interesting also, the case of the acquisition of material influence. So in October 2024, ECA received a notification concerning an acquisition of a minority stake in a target firm. So we had an investment fund with a lot of affiliates, portfolio companies, and then on the other side, we had a target firm with also some number of affiliates. And after assessing the overlaps between the activities of the affiliates of the two groups, we discovered that there is a horizontal overlap between two affiliates from the side of the target and the side of the acquiring group and the hospital, also in the hospital sector. So here the primary risk was that the acquisition would help the two hospitals to share commercially sensitive information via the presence of the acquiring group on the board of directors of the target group. So here ECA imposed behavioral remedies, a number of remedies, in order to prevent any exchange of commercially sensitive information, such as strict separation between board representation between the target and the acquiring group, for example, confidentiality agreements binding the representatives of the acquiring group on the which will be present on the board of directors of the target group, and a number of remedies in order to ensure the separation and the non-exchange of commercially sensitive information between the two groups. And I think this particular case is very interesting because first it highlights that ECA would have the opportunity to assess some notifications or some transactions that may not be notifiable in other jurisdictions, and and have also the ability to and the capacity to design behavioral remedies proportionate to the concerns in question, and not to systematically block mergers that may have economic efficiencies and may have also may be beneficial in the broader term. Thank you so much.
Thank you very much, and thank you very much for pointing out the fact that in merger control there are two types of remedies, structural remedies and behavioral remedies, and for your thoughts about the fact that you may want to look at behavioral remedies when the merger, even though it's anti-competitive, may have some redeeming values, particularly in terms of efficiency or others. Let me turn now to the Moroccan Competition Council and to Shemai Abu. We've heard that you have dealt with a great many mergers. So can you give us some sense of the trend of enforcement in Morocco?
First of all, sorry for the camera issue. And I would briefly share an idea about fast-track procedure before to move to enforcement cases. Mainly, it usually takes 60 days to review a merger if the case is more complex. The review can take up 120 more days. And for simple cases, we introduced a fast-track procedure deals where there is no real competition concern. In 2025, about 74% of cases were handled through a simplified and faster procedure, introduced to manage more cases while keeping strict review for complex ones. It means companies get faster, more predictable results on standard transactions, and it frees up the council analytical capacity for the cases that truly need it. I believe that a merger control system that doesn't enforces its rules is not a real competition regime. It's just administrative formality. In 2025, the Moroccan Competition Council handled 6 contentious cases. 2 related to anti-competitive practices, and 4 related to merger notification failures, what we call gun jumping. And total fines exceeded the 23 million Moroccan dirham. The council has become more focused on 2 issues in his exercise. The first is gun jumping, when companies complete a deal before getting approval. And the second is when companies don't respect the conditions attached to an approval. The council is also taking a more proactive approach. When a company files a new merger notification, investigators may review its previous transactions to check whether all notification requirements and commitments were respected. This approach helps reduce non-compliance and also sends a clear message that companies are expected to follow Morocco's merger control rules. Examples include Viatri's decision and Veolia Suez decision. For more details, the Viatri's case is a clear example of gun jumping, where an international transaction structured and implemented outside Morocco and still had a direct impact on the Moroccan pharmaceutical market, yet the parties didn't notify the operation to the council. After reviewing the case, the authority confirmed that it had jurisdiction under the local nexus test. Because what matters is not where the transaction is agreed or implemented, but if it affects the Moroccan market, it can impose a sanction for not notifying the transactions. The key lesson for practitioners is clear but important. The geographic location of a deal is not important in merger control. What truly matters is its impact on competition in Morocco, meaning that any transaction with local effects must be notified regardless of where it comes from or is arranged. About the Veolia-Suez case, this case is about a merger that was approved, but only under strict conditions. The Moroccan Competition Council allowed the deal between Veolia and Suez, but it wasn't a free approval. The council attached conditions, and one of the most important was that the companies had to sell, to divest a business called Lyonnaise Lidec within a specific deadline. At first, the deal was clear, but later the companies didn't respect the deadline of selling Lidec. So the conditions were not fully followed. In response, the council stepped in and enforced its decision after the approval. The key idea is very simple. When a competition authority gives approval with conditions, those conditions are legally binding. They are not just promises. Companies must respect them exactly. And if the authority does nothing when conditions are ignored, then those conditions lose their value. But in this case, the council showed that it monitors compliance even after approval and can act if companies fail to comply. I hope that this answers your question.
Thank you very much for this, and thank you very much for bringing an issue which is an important issue. We talked about briefly structural remedies versus behavioral remedies. And what in the case that you have explained, you have said, well, when you impose behavioral remedies, it's not obvious that the firms are going to actually behave the way they should be. And that requires some checking by the competition authority and stern rebuke if they don't actually implement the behavior that they said they would. So at the international level, this is one of the reasons why some competition authorities have said, we prefer to have structural remedies because we don't have to monitor them, tell them no to the merger and that's it. Or you have to divest an asset and that's it. But at the same time, as we saw earlier, there are cases where the merger may have some redeeming value, so you don't want to be as strict as this. So you want to impose behavioral remedies, and you explain how in those cases, then the competition authorities should have the means to check that those behavioral remedies have actually been implemented. So let me turn now to Mr. Baimer. Mr. Baimer has been active in many of the countries, or all of the countries that we're dealing with today. And it would be particularly interesting to have your perspective and your comparative perspective as on the side of the parties of the proceedings and the developments that you've seen in merger control. So, Mr. Baimer.
Thank you very much. Yeah, maybe to pick up on 2 points that came up during the previous discussion. The point of Mohammed stating that they chose not to go to an official violations procedure, that is actually something that we have seen across the region. Regulators take in the initial phases, similar to what Mohammed described, out of an pragmatic understanding that these emerging merger control regimes might not be as well known yet. I would be, from a party perspective, careful though to rely on that because, and I think Mohammed, you alluded to that position might change. And for example, in Saudi Arabia, a country that started a little bit earlier, we've seen a similar initial approach that they were somewhat lenient in the first potential violation cases, but then have shifted to enforcement when they felt these considerations of less notoriety of the regimes were not really valid anymore. And Saudi Arabia took the decision then to sort of still consider settlement, but settlement in much more rigorous terms. And that is something that parties need to be prepared for, that even in jurisdictions where initially a regulator might take a more lenient approach from a pragmatic view, that will often change with the regulator feeling more established and the regime more established. And so there is this danger of, as Frederick, you alluded to, also like testing the regulator because there will be a shift typically. And I think that came from all of the three previous speakers, that if regulators would not do that, they would likely be seen as teethless. And so there is a natural understanding why I think everybody should understand why they would take that position and go forward with that. More generally, what we see from parties in their dealing, or their challenges when dealing with investigations, not necessarily violations. I mean, not every investigation leads to the conclusion that there is one. Changes a little bit whether we are talking about regional firms or local firms or international firms, in particular firms that come from jurisdictions that have a longer antitrust enforcement or merger control enforcement tradition. From the local firms, we often still see less knowledge within the institution about these processes and also their obligations, which in some cases might lead to violations, but also when they're faced with investigations, they tend to have less experience in how to deal with the regulators. If you're the target of an investigation, of course, and specifically in the Middle East, I would say there is a greater deal of compliance and deference to the regulators. But you might have some investigations, more so on the behavior antitrust side, maybe a little bit more, but also on even during merger review, where third parties might be pulled into the process by the regulator to, for example, in their market study, when they want to assess the potential impact of a transaction. And we have seen local firms or regional firms from the Middle East become very nervous in these situations because they're not used to these type of processes, and they might not understand that they are not a target of an investigation, but rather asked to give their comments and engage in that manner, that they're not under threat themselves, that they're just asked to lend their experience and their expertise so that the regulators can do their work. But we have seen in all three jurisdictions that are represented here, and also in the broader Middle East, ambitious awareness campaigns from the regulators to address that. And so I would expect that to change, not only because more engagement happens, but also through these awareness campaigns. When it comes from the international firm side, they're often used, whether that's Europe with the European Commission or domestic regulators that have a longer tradition or longer activity, or in the US, FTC and DOJ have been active in this area much longer. There often is a certain expectation of how a process would work in their home jurisdictions. And there we often see expectations that then don't really meet the process locally. And there has to be an acceptance and an awareness that we're dealing with a region that is some jurisdictions are a little bit more established. Egypt has a longer behavior antitrust enforcement history. Saudi Arabia is now active since about 7 years, but as you see, for example, with the UAE, that just started very recently, Morocco is somewhere in the middle. The regulators are also developing their processes, and you see that with new regulations coming out, guidelines being published, procedures being amended, and sometimes we have the difficulty from from the private sector side, that there might be expectations of how a process works, let's say at home, and then being surprised of a process running differently locally. And that may be due to experience being built up, but it also has cultural issues. And I don't mean cultural in the sense of ethnicity or something like that, but also in the understanding of how the public sector, so the authority and the enforcer, interact with the private sector in certain jurisdictions. And that requires, from the side of parties that are either investigated or pulled into a process as a third party, a certain amount of openness to engage with these processes that might differ from their process, what they're used to from their home jurisdictions.
Okay. Thank you very much for this. And for pointing out the fact that processes may very much depend on local circumstances, and therefore or local tradition, legal tradition, as well as institutional setup, and that one has to be ready to face those differences from one jurisdiction to the next. We have to accelerate a little bit to stay within the time frame that we were given. So on the third part, which is the question of challenges, I would like each speaker, in fact, to tell us what is the most important challenge that you're facing. So far, we've talked about achievements, I would say, and they were very impressive. But maybe there are challenges that you're concerned about. So I'd like to start with Hana Koueld from Egypt. From the Egyptian side, what do you see as being the biggest challenge in the merger control area for the Egyptian Competition Authority?
Thank you, Professor Jenny. I think that the most and the bigger challenge that ECA has faced was how to build trust and an open communication channel with the parties and their legal representative. Because as you may know, the merger control regime was adopted in a context where concerns about its potential impact on investment flows had long been part of the conversation. So it took a long time to build a consensus that when well designed and well implemented, merger control is a tool for markets to remain competitive and to push investments to their full economic benefit. So, as I said, the most important challenge was to build trust and an open communication channel with the parties and their legal representatives. So, ECA took a number of steps First, we have established an email, a dedicated email for inquiries, and we have been committed to respond to these inquiries within 48 hours. And then we also have published a number of guidelines regarding ECA's jurisdiction, regarding ancillary restraints, regarding gun jumping, and a two-part Q&As on the provisions of the law and the executive regulations, and also consolidating all the inquiries received by ECA. We have also developed a tool, a calculator tool on ECA's official website, which is basically a tool that helps the parties to conduct a self-assessment and to calculate whether the notification thresholds are fulfilled or not, and the applicable filing fee accordingly. Also, ECA has structured a simplified procedure for transactions that are unlikely to raise competition concerns. It consists of a streamlined notification form and a fast track merger review process, which is 20 working days instead of 30 working days in phase one and 60 working days in phase two. So I think that these steps have helped the ECA to build certain communication and certain trust with the parties. Of course, there are a number of challenges that remain, such as the data availability or the how to raise awareness about the particularities of the Egyptian regime, because as Nicolas has mentioned, most of the parties and their legal representatives are experienced in EU and US law. So naturally, they draw these regimes as the reference point. So I think that it's very important for regulators to always raise awareness and to highlight the particularities of their regimes and to explain why and how for the parties and the legal community in general. Thank you so much.
So thank you very much. I mean, I think that you're quite right that building trust and understanding of among the businesses is usually important for the institution. And I'm personally reassured, and I'm not speaking about any country in particular, but by the fact that I would say that overall competition authorities are seen as trustworthy partners in the world. I mean, they are a type of institution which is fairly respected. It doesn't mean that everybody always agrees with their decision, but it means that people in general think that they work well, and in the sense that they take decisions which are motivated and which are not unduly influenced by particular interest. So, but you said that communication and transparency are usually important precisely to build this kind of trust. Let me turn now to the Moroccan Competition Council and to Shemaya Abu. What is the biggest challenge that you think you have at this point?
Briefly, the recent reforms have upgraded the Moroccan merger control, introducing clearer thresholds, simpler procedures for easy cases, and more legal clarity and security for business. However, implementation is still an ongoing process. Another challenge is the growth of the economy and the more complex transactions as markets become more connected and cross-border deals increase. I think that the Moroccan Competition Council must review more sophisticated cases, especially in telecoms, energy, digital sectors. And the key challenge really is the digital economy. because the traditional tools focus on prices, market share, but today competition is driven by data, innovation, technology, and network effects. And digital companies may, by emerging competitors early, even before they make significant profits, which makes assessments more difficult. Another challenge, sustainability and innovation, is how to include sustainability and innovation in merger control. Many authorities now consider ecological impact and long-term consumer welfare. I think that Morocco may also move in this direction because sustainability becomes more important in economic policy. Also, the simplified procedure must work effectively in practice. Success depends not only on the law, but also on fast, clear, and predictable decision-making. Businesses, I think, need legal certainty when planning investment. And the main challenge is finding the right balance between strong competition enforcement and an attractive business environment. The reforms are a strong foundation, but the system must continue adapting to market changes. Thank you.
Thank you for that. That reminds me of a debate that there was, not in particular with respect to Morocco, but at the turn of the century when there were discussions about whether in the WTO there should be some kind of competition dimension to the WTO. And this discussion was going on both at WTO and at UNCTAD. And one of the arguments that was fairly often used was the fact that, if we developing countries adopt competition law, this is going to prevent firms from investing in our country. They're going to invest somewhere else. And there was some very useful work which was done by UNCTAD, the investment division of UNCTAD, which showed very clearly that this is absolutely not true. In a sense, competition businesses are reassured when there is a competition authority which is well established, that they are not going to be the victims of local practices that would make their access to the market or their investment in the country more difficult. So there doesn't seem to be any truth to the fact that competition law, when it's well enforced, threatens other innovation or investment on the part of partners, even though it has been argued mostly by the business community to try to avoid competition laws that were strict. Let me turn to Mr. Janahi. What is your challenge in UAE as you enter this domain of merger control?
Thank you, Frederick. So, I mean, other than the expected challenges for an emerging competition authority that still sits within a ministry. So we've got the independence question, resourcing, capacity, awareness. So those are the typical issues. But we have a particular challenge, I think, which makes it more complicated for us, let's say, a fairly small economy. And maybe my colleague Shema touched upon it when it comes to the certainty from businesses in light of our law, our competition law, allowing not only us as the federal regulator, but the 7 emirates that make up the UAE to have their own, to take on the competition law and apply it by themselves, and how to create consistency, certainty, I wouldn't say uniformity, but at least clarity for the market on how these, what are the different approaches in each jurisdiction, when, of course, the jurisdictional and economic impact tests are met, then it goes to the local authority. And to make it even more complicated and harder for the private sector, I think, the federal regulators, the federal sectoral regulators, can also implement the competition law for their respective sectors when they choose to do so in the absence of a competition law within their remit. Or based on agreement between them and us, we can take on those issues. But you see, all these questions remain. And I think from the private sector side, looking at the competition law, a lot of questions remain. And I think we have a lot to do to, in cooperation with our stakeholders in the local emirates and the federal regulators, to raise awareness on how we're planning to implement this law and what strategies are we putting in place to cooperate on that.
Okay. Thank you very much. And I hope that some of the ideas which have been mentioned before by other countries which have gone down this route earlier will be useful. And in particular, what was said about transparency and communication as being a useful thing. And of course, I mean, but one would have to see whether this could be useful. Europe, of all the regional competition authorities, of course, Europe has been confronted with exactly the same problem. How do I ensure that the federal level is in sync with the competition law enforcement in each of the country? And I think that the experience of the ECN, the European Competition Network, where there is close cooperation and collaboration, I would say, between the competition authority at the level of the Commission and the National Competition Authority, is a good institution. Then with the other regulators, this is an issue in many countries. How does the what's the division of labor between the telecom regulator and the competition authority when it comes to the telecom sector? Again, there's been quite a bit of work which has been done, and there are different models. So we don't have time to go into this, but this is an issue indeed that has various types of solution. So let me turn to the private sector, and what do you see as being the main challenges?
I mean, one central challenge still remains deal timelines. We're dealing with, in some jurisdictions in the Middle East, more established, in some more emerging regulators. And so for one, there's less experience with deal timelines, and also sometimes, in addition, some uncertainty over certain principles of competition law, specifically within the merger control regime, and the application to certain principles, which can make deal timelines a little bit less predictable. There are ways for parties to mitigate that. In several MENA jurisdictions, you can make filings based on LOIs or other preparatory documents. So submissions could be made early stage. I'm obviously conscious that in some deals that might not be possible, especially if you're in a bid procedure. Parties might not want to put in the expenditure of going ahead before they even know whether they're ultimately going to be successful in the bid procedure. But one issue also is that the MENA region, from a merger controls perspective, is overall still seen as emerging. And so in some transaction, the primary focus might be on more or longer established jurisdictions. And at some points, clients might come to us at a fairly late stage, which then makes timeline management a challenge, not because necessarily a timeline in a certain jurisdiction is longer, but just because we're late out of the gate. That I do see changing, and it depends from country to country. just because we have different times at which they would have started their merger control regime or becoming more active, and parties just have different experiences and might not be aware of certain new emerging requirements. That I think is one of the key or is a key issue that still arises. The other point is that again relates to we're dealing with a lot of times emerging merger control jurisdictions, that we have little local precedents. There just has not been the opportunity for regulators to weigh in on certain markets. And Shaima, you touched on that, I believe, by saying you see the council needs to sort of establish itself a bit more in certain markets. The problem, obviously, for the regulators is they cannot themselves select which markets they're going to look at. They need the transactions to come to them. But we might not have specific market definitions from regulators, and then the approach often is, I mean, the understanding you don't have to invent the wheel twice. You can look at other jurisdictions and how they have resolved that and present that to the regulators, but you have to be aware that obviously the regulators are not bound by other decision and will make their own or might take their own approach to a specific market. But those are, from the private sector, I would say, currently the main challenges.
Okay. Thank you very much. We've got very little time, so I'm going to be very strict on the last topic, which is cooperation, and by asking you to limit yourself to one sentence, which is summarizing what you want to say on cooperation. So let me turn first to the Egyptian Competition Authority, to Hana. What has been your experience, and what do you want to say in one sentence?
Okay, so for us, the Egyptian Competition Authority, cooperation is a cornerstone for the implementation of an effective merger control. I think that cooperation is not merely a formality, especially for young authorities in the MENA region where merger control is still developing. I think it's a source of credibility, source of regulatory strength, and source of analytical depth also. I think I will stop here in order to give the opportunity for the other speakers to share their point of views.
Thank you very much for the 3 sentences. Yeah. So, Mr. Jahani, I understand that UAE is signing MOUs for cooperation. Can you, in one sentence, tell us which country and why you think it's important?
So we've signed with Egypt, our colleagues present here, and also others in the pipeline are coming from China and Brazil. We've also signed the BRICS competition multilateral MOU. So I think those 3 countries have specific and important trade ties with us that necessitate us cooperating with each other, and we will. The topic of international cooperation is still being improved, I would say, here, and by the BRICS multilateral MOU and the capacity building initiatives available there helps a lot.
Okay, thank you very much. Let me turn to the Moroccan Competition Council, and what has been your experience in cooperation, and what do you think are the most important points in one sentence, of course?
Okay, in one sentence, for Morocco, one of the main platforms for regional cooperation is for sure the Arab Competition Network. Morocco also cooperates actively with major international organizations, including the International Competition Network. which brings together more than 140 competition authorities worldwide, the OECD and the European Union through various technical assistance and capacity building programs.
Mhm. I mean, do you find this cooperation useful?
For Morocco?
Yeah, for Morocco. In other
Yeah,
words, does it help you in cases? I mean, let me put it this way.
Yeah, for sure. Cooperation main benefits in knowledge sharing, allows competition authorities to learn from each other's experiences, discuss new challenges, and improve enforcement practices. Yeah, for sure, it helps to reinforce competition law across the world or the MENA region.
Let me turn same question, I would say, to the private sector. What do you think about cooperation between competition authority on mergers? Do you think it's sufficiently developed, that it's satisfactory, that it's opaque and not sufficiently transparent for you?
In the MENA region, it is emerging. The Arab Competition Network is the broadest effort so far. It requires parties, or I would say the best approach for parties to deal with cooperation between the authorities is maintaining consistency in your filings, in how you present your transaction, and how you engage.
Okay. So I think that several of you have emphasized the importance of regional cooperation, if for no other reasons, because countries tend very often to have more economic dealings with other countries in the region. And I think that this is a particularly important dimension when it comes to cases and when it comes to cooperating on remedies or cooperating on analytical principles in cases. So the development of the Arab network is really important from that standpoint. Okay, thank you very much for all this. We have still a large number of people who are online, which means that they must have been interested. But we also have a number of questions which have been raised. So I'm going to ask the various questionnaire to raise your question, and we will try to have sharp answers so as to take as many questions as possible. Let me start with Taimun Stewart. Taimun, if you're online, can you tell us what your question was?
Thank you, Fred. My concern is that the digital sector is a fast emerging sector, and that while we in the developing countries are still nascent, far behind, we do have the big techs operating in the countries, and that there could be small startups in our countries, in the MENA region. But the threshold does not capture such mergers. And my question was, have you all thought about including in your threshold provisions such wording as to capture the data value of firms as opposed to assets, where such firms have very little assets, but the value resides elsewhere?
Yeah. I don't know if anybody wants to answer that question. This is certainly one of the issues which has been discussed at the international level on how you catch mergers in a global sector, and what do the threshold mean. And I personally think, by the way, that this is certainly an area where cooperation between competition authority is even more necessary than in any other sectors, because a lot of those issues are absolutely global issues. and to try to solve them at the national level, raise the question of whether one can make a difference. And the answer is that one can make a difference if one cooperates with many other competition authorities. But having a merger control in every country of a global merger or global transaction is certainly a huge cost for the emerging parties, but also a huge cost for the competition authorities. Mr. Bremer, maybe you have an angle on this.
Like, unlike, for example, with the most recent review of the COMESA regime that introduced a specific digital merger threshold, we haven't really seen specific thresholds emerging, and I think that's also difficult to do. As you said, it's not a challenge that just emerging economies are dealing with. Even established regulators like the European Commission is still trying to find a good approach to this. I think what was helpful in the Middle East, while not necessarily only focused on merger control, but also on behavioral issues, is and Hannah, you can probably speak more to that, but the 2025 guidelines on digital markets and the ECA, the Egyptian Competition Authority's approach to that, because something that Taimun, you mentioned, there is obviously the element of thresholds, like how do we or how does a regulator catch certain deals? But there's also the assessment part to it, and for example, what is central to the guidelines in Egypt is the awareness that when you deal with digital markets, the traditional approach of looking at revenues or assets might not actually give you a proper idea of market dominance or market power of certain players. Look at something like Google Maps for a consumer that is entirely free, and remuneration of Google is done by other means. So if you would just look at paid subscriptions, you might not get an accurate idea of what the market standing is. So there's other means. There's active user data. There's also transaction based, like how many transactions, download based, different approaches. But I think everybody worldwide is still trying to find their ways, and it's not something that is just developing in the MENA region or that's just challenging. And I think the Egyptian model of the guidelines and the approaches explored there are a very helpful, I think, approach in this area.
Yeah, actually, Nicola, I think that we have, I can talk about the jurisdiction part and the substantive part as well. So for the jurisdiction part, the law included a call-in option, meaning that if the one transaction does not fulfill the notification thresholds, we can still review the transaction within 1 year after the implementation, when it may harm innovation, for example. It may harm competition, and the law clearly define the factors that should be taken into account when deciding whether or not to use this call-in option. And here we can only issue a commitment decision, a conditional clearance decision limited to behavior remedies only. Regarding the substantive assessment part, we have issued our guidelines on the substantive assessment in digital markets, which includes factors that should be taken into account, specifically in digital markets when it comes to defining the markets, when it comes to market power and theories of harm, and so on.
There are a number of questions which are addressed to the Moroccan Competition Council. So what I suggest is that we take them all together, and we'll give the floor to Abu. So the first one is by Rory Macmillan. Rory, are you online? No? Okay, Rory doesn't seem to be online, so let me...
Do you hear me?
Oh, yeah.
Okay, great, thank you.
We can hear you.
I had to be unmuted. Yeah, it's just a question about the general interest provision of the Moroccan law, which allows the minister to override a decision of the Competition Council on a merger, whether that's been used or not at any time, whether there are any guidelines on how it might be used. It's not dissimilar to the French law or maybe the South African law, although in South Africa it's the actual Competition Commission itself which bundles general interest issues in to the competition analysis. Thank you.
Okay, thank you very much for this question. There's another question by Odi Stridham. So Odi, if you are online, I mean, can you raise your question?
Good day, Professor. Thank you for the event. Yes, I have two questions and they relate to the decision-making bodies. We note that there are decisions issued by either the council itself, I think the English translation is the competition section, and then also by something which is called the standing committee. And I was just wondering what the differences are in terms of those two decision-making bodies, whether they're looking at the same types of mergers, whether their decisions are final. And the second question pertains to the issue of gun jumping. I understand that in certain instances, the Competition Council will not issue a decision of a current merger if previous mergers have not been regularized or finalized or made good. And I was just wondering whether that is indeed practice and if there are provisions in the law allowing for that. Thank you very much, ma'am.
Thank you. There is a question by Logan El Shafi. Are you online? I can read the question if Logan is not online. The question is the following: for Morocco, under the current competition framework, is exclusive. Oh, okay.
Oh, sorry. I was trying to unmute. Yeah. So I just wanted to ask, under Morocco's current competition framework, are exclusivity arrangements considered restricted by object, or anti-competitive effects have to be proven or demonstrated for the regulatory body? Thank you.
Okay, so let me turn to Morocco to see those questions. I mean, to have a short answer to all of those factual and more weighty questions.
For the first question of Rory, to the best of my knowledge, this power has not yet been used publicly in Morocco. And there is no specific guidelines have been issued on how the ministry would assess general interest consideration. In merger control, decisions have so far remained primarily within the Competition Council's remit. I hope that my answer clarifies the point.
Okay, that's good. Do you want to answer the other questions as well, or you've answered all of them?
The second question: how do Morocco view the review's draft merger guidelines process? Thank you for the question. I don't have the necessary elements to provide a well-founded answer at this stage. Sorry.
Okay. So let me turn now. There are three questions, I think, for the UAE. One of them is by Mo Alfar. Mo Alfar, are you online? Doesn't seem to be.
Sorry, Frederick. So Mo Alfar,
Hello?
speak. Yes.
Hello?
Yeah.
Yes.
Go ahead.
Hi, Mr. Junahi. I have a question regarding exclusivity. You've mentioned exclusivity, that there's an investigation on exclusivity. If you can shed more light on this case, if possible. and also whether you would the UE authority does prohibit exclusivity in case of dominance by object or by effect, i.e., per se or rule of reason. We would appreciate your guidance on this point. Thank you.
Okay, so I mean, I think that's all. Well, there's a general question that is addressed to not only UAE but also Morocco and Egypt from Kawel Risade. Is Kawel Risade online?
Kawel, please unmute yourself.
Sorry?
Kawel is online.
Okay.
Can you
raise your
mute
voice?
yourself, Kawel?
Yes.
I think we can read out loud the question, Frederick.
Okay, so I'm going to read the question. How do UAE, Morocco, and Egypt competition authorities view the revised draft EU merger guideline process? Are there any concepts that are potentially viewed as worthwhile being taken on board, particularly the effect-based toolkit that moves away from the standard categorization into horizontal, vertical, and conglomerate effects? That may be a bit early to ask this question, but we'll see whether there is already an interest. I'm saying this because the revision of the guideline is in process, but it's not yet final. Okay, so let me turn to Mr. Janahi on the question of exclusivity and the question of the revised European guidelines. What are your thoughts?
Yeah, thank you, Mo, for this question. So we've had actually two investigations which ended regarding exclusivity, one in the technology sector and one in the healthcare sector. Entities in dominant positions have entered into exclusive arrangements in a way that in an anti-competitive manner. So one of the issues was settled, and then a monitoring trustee was appointed to ensure that the issues have in fact been rectified. And you know, with settlements come a settlement payment. I wouldn't call it a fine, but it was double the minimum fine. So, and the other one actually hasn't been settled, and it was referred to the public prosecution office, and it's currently being litigated in courts.
Thank you very much. I don't see anybody willing to answer the question about the influence of the revision of the.
I want to answer.
Okay.
Audi. I want to answer
Please.
Audi. About the standing committee, la commission permanente. It's a decision-making body within the competition council. Typically deals with simple cases, while more complex or significant cases may be examined by the full council. And for the second question about publishing decision in Morocco, merger decisions are published in the official gazette. So there is a degree of transparency and access to the competition council's practice. And we publish in the official website too every week. So it's very transparent.
Okay. There is one question from Professor Casoria. I don't know whether she's online, but the question was for Nicolas Bremer. Professor Casoria?
Yes, good afternoon, everyone. And my question for Mr. Bremer is the following. Given that in the Gulf Cooperation Council, the Saudi General Authority for Competition is currently the most active in terms of enforcement, do you think that the Saudi merger control framework offers a transferable model for the other GCC countries? And if yes, for what aspects or what terms? Thank you.
Yeah, thanks for the question. I mean, yes, Saudi Arabia has the longest history of active merger control enforcement. However, if we look at different jurisdictions, there are somewhat differing approaches. For example, one point that came up several times is that Saudi Arabia focuses on decisive influence, more akin to what the European Commission is doing, but Egypt has a model that takes into account material influences, more akin to what the test is in Germany or by the CMA in the UK. In terms of how they define their thresholds, there are a little bit different aspects. So a copy and paste approach is, I think, not fitting and also not advisable, because obviously regulations also are driven or shaped out of administrative as well as legal tradition within the different jurisdictions, where I think the Saudi model can be somewhat educative for other jurisdictions, is sort of looking at the processes and the challenges, as well as how these challenges were addressed by the GAC, the Saudi regulator, over time. They might be a little bit easier transferable to other Middle Eastern jurisdictions or even North Africa, because of more cultural similarities, also within the legal frameworks. And other regulators that have a little bit started with their regime somewhat later might be able to avoid certain issues in the beginning by taking into account the experience from these other regulators. But beyond that, I don't think that it would be feasible to simply adapt certain elements of the Saudi regime. I mean, these have to fit into the broader regulatory and legal regimes of the jurisdictions. So ultimately, I would say yes, experiences can be helpful and understanding them, also consulting with them. But simple transfer of regulations or provisions is, in my opinion, not advisable.
There is one question which we haven't dealt with from Marine Cassin. Are you online? And it's addressed to everybody, so that's why I thought it would be interesting to finish with this question.
He already left the webinar.
She already left. Okay. So the question was, do you see, generally speaking, the increasing rise of antitrust and merger regulations in the MENA region leading to a growing number of participation from international firms that traditionally enter the local MENA market through minority joint ventures? So do you think that this is going to be, I mean, how is this going to affect, if it is going to affect at all, this kind of entry on the MENA markets? So, Bremer, you're closer to than anybody else to what the firms want to do or don't want to do.
I mean, similar to what you have said about the discussions on the international level of whether competition law would hinder investment, I don't see a decrease in investment or willingness of firms to enter the market. And yes, it is correct that a merger control process does put burdens on the parties, both acquirer, target, and also the sell side, and it increases costs of dealing. But ultimately, in the grander scheme of transactions, unless we're talking about very small transactions that are likely not caught by the merger control regime anyways, these are handleable cost implications. I think where it becomes difficult for companies, more so than from the cost aspect, to go forward with a deal is the timing item. I think that is often in cases the most important thing, and it differs a little bit from sector to sector. But if you look at, for example, the technology sector, the target that you might want to acquire might have outdated technology by the time you went through a lengthy regulatory process, and there it might be an issue. But overall, at least as far as I can see, there has not been a negative impact on inflow investment into the region that would be traceable to increasing merger control oversight. And on the other hand, and they're bringing, for example, in the Egyptian model, the Egyptian military is very commercially active in Egypt, and that has raised some concerns because of the strong position that the Egyptian military is in as a commercial player in Egypt by foreign investors. But the Egyptian Competition Authority has considered competition or neutrality in competition issues quite consistently in their practice. And so to the contrary, we've actually seen the competition regime and their view on maybe established dominance or influence patterns in an economy as positive for investment.
Thank you very much. Just a very last point. One of the questions was on the publication of decisions. It was really more a comment than a question, saying that what new jurisdiction needed, or what would be useful at least for the parties and the firms that want to merge, is to have published decisions. And by published decision, I assume that what was meant was decision with the reasoning which has led to the determination of whether or not the merger was accepted or not. Let me turn to each one of the three competition authorities here. Do you publish reasoned decision? Are they easily accessible? And if you don't, do you have any plans to do it in the future? So let me first start with Mr. Janaei.
Thank you, Frederick. We don't do it right now. But having said that, we want to move in that direction, including for other enforcement matters.
Okay. Let me turn to the Moroccan Competition Authority.
Yes, as I said, in Morocco, all merger decisions are published in the official gazette and on the website.
Okay. And Egypt?
In Egypt, we publish our decisions, and especially when it comes to conditional clearances, we publish a detailed version of the commitments to be followed by the parties. However, we are planning to publish a non-confidential version of the full report of ECA in order to provide more legal certainty and predictability about the analytical approach that ECA would follow in merger control.
And let me ask a question to Mr. Bremer. My understanding is, but I want to control this, that in Saudi Arabia, there may not be the publication of the reasoning that led to a decision. Is that correct? And,
yes.
And is that likely to change, or as far as you know?
I could not tell you whether there are plans to change that in Saudi Arabia, but you are correct. Reasoning is not published. You have a very short announcement of the decision typically. If remedies were assigned, you have that will just include the remedies imposed. but it will not include findings. And I'm not aware of any plans to change that.
Okay. But seen from a general point of view, I mean, it is true that one learns a lot about how the competition authority reasons by reading the decisions, even on mergers in which one is not involved. And certainly we were talking about transparency and communication, and publishing decisions with the reasoning is tremendously helpful for people who want to comply with the law, because they understand it better. They understand better how it is being applied. So I think it is, generally speaking, unless there are particular reasons in a given country, but considered to be a good practice to publish the decisions. I think that we have exhausted ourselves, probably exhausted the people who were attending this seminar, and certainly exhausted the speakers. So I want to thank them very much for their very active and lively participation to this. It's been very interesting, and you have answered pretty directly all of the questions. So I'm sure that a lot of us have learned quite a bit about the state of the debate on merger control in your country. We wish you very well. All of you said that you have challenges, and we hope that those challenges will be solved fairly rapidly. But I'm personally very encouraged by what I've heard today in the seminar, because they seem to be a shared understanding both of the importance of having merger control, but also of doing it the right way, and of the various dimensions of the issue. So I think this is very reassuring. So thank you to Concurrence for having organized this debate, and hopefully we'll see each other in another debate soon. But thank you for your participation.